So, good morning, everyone. I am so glad that everyone came for this very important information. We have a phenomenal speaker this morning, and we're going to get moving pretty quickly. So, first of all, I just want to say this presentation is part of our group. I'm sure many of you remember us. We're back now. We're getting ready to roll again. And I'm Vanessa Nelson, and my co-chairs are Katrina Royston and Geraldine uh, Klitsch. Okay, let's get this moving. All right, and just a little background about the co-chairs. I am the founder and president of Expert Human Resources, been in business. This is my 16th year, and it's been a wonderful ride. I've also authored the book 101 Costly HR Mistakes and How to Fix Them. Certified EEO investigator. I work for what they call NEOSO, National Equal Opportunity Employment Investigative Offices. And that's just a little basic information about me there. Katrina Royster, who's just the most wonderful person, Director of Human Resources for Valley Area Agency on Aging. She's also has her master's in organizational management, and she's very smart. Katrina, did you want to say anything this morning?
Yes, first off, where did you get that picture? Wow. But no. Um, good morning, everyone. I'm just ecstatic to be here in this space with you all. It's been like Vanessa said, a ride, and we've been through some things as a country and back in this space, but virtual. So hopefully it was convenient for most to log on this morning. You didn't have to drive out in the cold and the snow and the slipping and sliding on the roads to get to the meeting, but you were able to click on a link and join here with us on today. So just excited just to be here with you all.
All right, thank you, Katrina.
You're welcome.
So it's admitting a few people there. All right. Reason this is not okay. And Geraldine, I'm not sure if Geraldine's here yet, but she is also a co-chair, and she's the human resources manager at Michigan State University. Very, very busy lady. She is also a faculty member of Saginaw Valley State University, and she has her master's in personnel management and human resources. Now, our speaker today, as I said, he's phenomenal, and I can't say that enough. He's really a wonderful speaker, and his name is Attorney James Reed. And Attorney James Reed is a partner at Honigman, I hope I'm saying that right, LLP, who has been recognized as the largest Michigan law firm by Crain's Detroit Business. He's a labor and employment attorney and a sought after expert speaker. Attorney Reed graduated cum laude and received his JD from Wayne State University Law School in 2005, so he's been at it a long time. He was issued the Distinguished Service Award from Oakland County Bar Association in 2014 and the Michigan Rising Star from Super Lawyers in 2015 and 16. He is a member of the Detroit Society of Human Resource Management and the Oakland County Bar Association. And we are very, very fortunate to have him today. And I'm going to take a second here and pull up his presentation. And it is here. See here. Beginning. Okay, that went smooth. Thank you. So, Jim, if you want to take over, if you want to say anything first, and just let me know when you want me to change the slide. I'll be glad to do that, sir.
I really appreciate everybody and what an honor to be part of this elite group. And I am happy to take today's conversation wherever you want it to go. So I am actively monitoring the chat. So what I tried to do is I read every single lawsuit in the past year involving employment law, or at least a summary of every lawsuit. And what I did is I highlighted about 68 slides of cases that are worth you hearing about so that you can issue spot at your own organizations if any of these issues apply and understand how to be proactive in avoiding all of the cases where the employer lost and also implement all of the strategies where the employer won. And before I get into these slides that are mostly national, I wanted to spend a couple of minutes talking about ESTA. And I joke that ESTA is really called MESTA because it is the Michigan Earned Sick Time Act, MESTA, because it's a mess. And you're right, it will be effective tomorrow, February 21st, unless somehow legislature agrees to delay enforcement until July 1st, as requested by the governor. And there are also a House bill and Senate bill with proposed modifications that have not been fully passed yet. And so at a high level, all of you need as of today to wait to produce tomorrow is a ESTA policy. And you also need to have an ESTA poster. So if you're not getting the legal alerts from me or Honigman, you can send me an email. Here's my contact info, or send me a text. There's my cell, and I'll be sure to get you on the alert newsletter. And essentially, you need to post in your break room an employee's ESTA rights. And the ESTA rights are for any company that is under 10 employees, you have to offer 40 hours of paid leave and 32 hours of unpaid leave that is at a minimum accruable by that employee at 1 hour for every 30 worked. And if you are over 10 employees, if you're 10 employees or more, then you would have to offer 72 hours of paid leave that will be offered 1 hour for every 30 hours worked. And why I call it MESTA is that it's complicated for a lot of companies because some companies already have a generous paid time off bucket that maybe is even more than 72 hours. And now they have to change it because ESTA requires employers to allow employees to take ESTA in 1/10 of an hour increments. So it says 1 hour or such smaller increments that you use to track time. And you aren't allowed to ask for a doctor's note until an employee misses more than 3 consecutive days of work. And if you want to ask for a doctor's note after that, you have to pay, the employer has to pay for the cost of getting that doctor's note. And the reasons for the leave include also taking care of anyone that is close to you, a close affinity. So you don't even have to necessarily be related. So the fear is employees could potentially abuse this by leaving on a Friday at 3 o'clock when the weather's nice. And really, you wouldn't be able to ask for any evidence supporting why they need to leave the office early. And there's also a entitlement for the employees to carry over their accruals to a subsequent year that can be capped at usage of 72 hours in any given year. But the burden of tracking it is going to create challenges for some employers. And the biggest issue is there is a private cause of action built within this Michigan law that says anybody that is terminated or has an adverse action within 90 days of any ESTA leave is presumed to be retaliating against that employee unless the employer proves otherwise. So it's essentially putting the burden on the employer to prove they're innocent or assumed guilty, as opposed to the opposite, where the employee typically has to prove that the employer violated a law first. So a question that came in is what happens to PMLA hours that are already accrued? So essentially, the Supreme Court in July said that the Paid Medical Leave Act is unconstitutional, void. So technically, you haven't had to follow that since that July case. And so what you would probably do for a morale purpose, or at least not violate your own handbook, is you would probably just either update that policy and replace it with ESTA, or allow employees to have additional PMLA banks that will run concurrent with an ESTA bank. So I would argue that starting tomorrow, to the extent you're already getting more than 72 hours of leave for the year, then you won't be entitled to any more time under ESTA. Or if you already have 40 hours under Paid Medical Leave Act, we'll supplement up to 32 hours more if you end up working more than 1,200 hours. For example, you only accrue 1 hour for every 30 worked. So if you're already providing 40, arguably they'd have to work more than 1,200 hours to be eligible for more. However, there's an art in drafting these policies. So you would have to update your policy today, or at least issue it by tomorrow, and be careful how it overlaps with other policies. For example, if your holiday pay policy says you'll only be paid out a holiday pay if you work the day before or after the holiday, you now have to revise that, because if there's any ESTA related leave, you can't punish that employee for taking that leave. Or if you have a point tardiness system, you can't assign points to that employee that has any ESTA related leave. So the key takeaway is you need an artfully crafted policy and a poster in your break room. And another great question is that if you have a collective bargaining agreement, there is another provision that says you can ignore ESTA, your CBA will control. However, the state of Michigan on their Q&A said that if your CBA is silent about paid sick leave, you should still follow ESTA. However, some attorneys on my team are challenging that interpretation because the law doesn't say that. So sometimes the FAQ under Leo doesn't necessarily have the authority to make law. So we could obviously spend the whole hour and a half on ESTA. I just wanted to give you that brief summary, but feel free to issue other comments or questions in the chat. Next slide. So what I want to cover today is a broad summary of various legal updates and cases throughout the country. And I'm going to talk about non-competes. So essentially, there was a proposed federal ban to prohibit non-competes for anybody that made under $150,000. That was struck down by a Texas court as unconstitutional. So you can still have non-competes federally and at the federal level under any wage category. And most states still allow non-competes. Michigan is one that does allow non-competes, even if you were receiving less than $150,000. But some other states prohibit non-competes. So you'd have to verify your local state law. And there is an art in drafting non-compete agreements. For example, some states like Michigan are what's called a blue pencil state, which means that if you overreach in the agreement, the judge still has authority to redraft it, mark it with a pencil as to what is reasonable. But in other states, if you overreach in your non-compete by saying they can't work anywhere within the country or several hundred miles and they have to move somewhere to get a job, that entire agreement may be voided out in that state for overreaching. Regarding the National Labor Relations Board, Trump fired the general counsel and is essentially pulling back on the board's authority. So we will likely see less pro-union activity at the national labor relations level. And the good news for employers is more handbook provisions will be more likely to be enforceable and not be interpreted as waiving an employee's rights to negotiate or engage in union activity. As far as wage and hour laws involving ESTA in Michigan, there are also wage and hour changes effective tomorrow. You have to change the minimum wage hourly and also change the tipped minimum wage. And nationally, the minimum wage laws also got struck down by a Texas court as unconstitutional. So there was a proposal to increase the exempt salary threshold at a federal level by $15,000 and change. That was struck down, but employees are feeling entitled to have a higher base salary if they're going to be exempt from overtime. And now is a good time to also double check your employees' job duties to make sure the job duties actually fulfill one or more of the exempt tests to be exempt from overtime. There was also a new federal law that adds additional protections to pregnant workers that I'll cover in more detail in later slides. I went over the Earned Sick Time Act. Under the Trump administration and the current Supreme Court, religious rights are stronger than ever before. So historically, the past 30 years, if somebody had a religion, for example, that said they needed to go to church on Sunday and miss work, the test used to be, does their religion have a de minimis impact on my business? And if the religion has a de minimis or more than a de minimis impact on the business, you could refuse an accommodation. Recently, the Supreme Court said you need to accommodate religious rights unless it has a substantial burden on your operations. So that is a major trend. So because of that, I recommend updating your handbooks to, at a minimum, include Pregnant Workers Fairness Act, Earned Sick Time Act, and how to ask for a religious accommodation if needed so that we can comply with the laws. I'll next cover some updates on Trump's executive orders. I'll get into more details on wage and hour matters. I'll cover more protected classes on equal opportunity laws. I'll cover the latest cases on disability laws. And I will close with some Family Medical Leave Act case law updates. Next slide, please. So these are essentially the top 6 issues that you need to be aware of at your organization. And essentially, you may want to start having a playbook for whether the president is Republican or Democrat, because often things shift. So when there is a Republican president or leadership, non-competes are more enforceable. NLRA rights are less enforceable. Wage and hour rules are more pro-employer. For example, the current administration would interpret the Department of Labor as not having authority to make up random salary increases without going through legislature. These agencies arguably don't have authority to make billion-dollar laws. They aren't judges, they aren't legislature. And we're going to see states that are majority Democratic run creating more pro-employee laws, like banning non-competes, creating more sick time. And when there is a Republican president, our religious rights will be even stronger. Next slide. So under the Biden administration, the NLRB was saying if you have non-competes and that employee is not a supervisor or above, they're essentially a lower level worker, you shouldn't make them sign non-competes because that could prohibit them from joining a union at the competitor across the street. And if you have certain things like the terms of employment are confidential, that could prevent them from complaining about working conditions and starting a union. And the NLRB didn't really want anybody to be an independent contractor because contractors don't have rights to join a union. So the Biden administration and the NLRB were making it much harder to have an independent contractor classification. The Trump administration will pull that back and make it a little bit easier to have independent contractors and minimize union rights. Next slide. Given that employees thought non-competes were going to be illegal, it's probably best for morale to draft an agreement that is more focused on non-solicitation of customers or employees, because that essentially can protect your business just as well as a non-compete and doesn't make that employee feel like they don't have other opportunities in life to earn a livelihood. So it's a great time to refresh your documents to help improve employee morale and also protect your legitimate business interests. Next slide. I already covered essentially changes involving the Earned Sick Time Act and minimum wage. For those of you that don't know the political story, is that in 2018, there was going to be a vote to the public of whether or not citizens wanted to have a higher minimum wage in Michigan and allow employees in Michigan to have paid sick leave. The Republicans knew that a majority of voters would say yes. So instead, the Republicans told the Democrats, don't worry, we'll pass your law. We'll work with you. No need to have people vote on it. Because if the people vote on it, then they'll have to have over a 75% majority, supermajority vote to change the law. But by not having voters vote, it only takes 51% of legislature to change a law. So what happened after the November ballot, the Republicans controlled the House and Senate, and they gutted the paid sick leave and minimum wage laws to be more pro-employer and created what is known as the Paid Medical Leave Act. The Supreme Court said in the summer, what the Republicans did, that bait and switch in the same session is illegal, and therefore the old law that wasn't fully vetted by Republicans has to pass as is unless legislature can figure out more negotiated amendments prior to tomorrow. Next slide, please. So on the paid sick leave law, I don't want to spend time going into it today, but there are a Senate bill proposal that makes it more employer friendly that you can read. And yes, there was a question of, will I share the slides? I will share these slides. So one potential change could be something similar to this slide that caps the amount of accrual hours you can carry over and makes small businesses be defined as 25 employees instead of under 10. Next slide. And the House also had their own proposals that have not yet been fully passed by the Senate, but did pass the House. And it is also more employer friendly, but still being objected to by the Senate. Next slide. I'm anticipating more litigation, not only for employees fired for missing work and tardiness policies, but also more litigation with pregnant workers, because the new Pregnant Workers Fairness Act essentially requires companies to make oral accommodations. So if your handbook says you got to ask for an accommodation in writing, you need to update that to allow these oral requests. And the law has a bunch of pre-approved accommodations you have to make as a matter of fact, such as water breaks, snack breaks, being able to sit or stand at their workstation. So you definitely want to update your handbook or train your employees on this issue. Next slide. As far as having employees exempt from overtime, you'll want to continue reviewing your job descriptions to see if they meet the job duties tests and evaluate the minimum salary threshold. But because it got stopped prior to January 1st, there is no additional expected change that is anticipated this year. Next slide. On the religious accommodations, I would also recommend adding an updated handbook policy that explains how an employee should ask for an accommodation. But we're going to have to be extra careful because even Michigan passed a law protecting hairstyles. And so be extra careful on how you enforce policies involving missing work, their look, dress attire, grooming, vaccinations. The whole mask and vaccination concepts during COVID likely would have been handled differently had this religious accommodation interpretation standard been in place back then. So be careful how you accommodate employees. It's not quite the same standard as disability, but it's pretty close. The disability standard is whether or not it's an undue hardship. The accommodation standard is a substantial burden. Next slide. There was a lot of people going around today wanting to know about the Trump executive orders, and there has been some changes. So my past volunteer role is I was the Michigan director of Michigan SHRM, my SHRM. And I currently serve as the legislative affairs director of my SHRM and some local HR chapters. And I go to DC annually to meet with Congress and get the latest updates. And currently, there is a major controversy on DEI. So SHRM essentially is changing DEI to ID on their business strategy approach. What they're saying is inclusion and diversity is great, but having the word equity is confusing to a lot of companies, and it's hard to define what that actually means. And President Trump issued an executive order essentially shutting down affirmative action and anti-discrimination laws applying to federal contractors and wanting more of a merit-based approach where you hire based on merit, not based on protected class. And so it is a good idea if you have any type of DEI policy or affirmative action policy, whether you're a private employer or federal contractor, to have it reviewed to make sure that you are not exposing your company to liability. And the order essentially says within 120 days, there must be a report to encourage the private sector to end illegal discrimination and preferences, including DEI. The order does not clarify exactly what would be considered an illegal DEI policy or program, but it would be helpful if you said your policy was at least approved by competent counsel. More questions in the chat. As far as religious accommodations interacting with the CBA, I would say that federal law would trump whatever provision is in a CBA. Next comment, someone had to drop and wants to share their LinkedIn info. I'll keep going. Next slide. There has been ICE raids throughout the country, including Ann Arbor and Detroit. So essentially, under the Biden administration, he is more lenient on immigration. And under the Trump administration, he is more strict on making sure the I-9s are filled out accurately. And you'll anticipate more raids investigating whether employees are authorized to legally work in the United States. Next slide. And just be aware, involving I-9 employees, if you are in HR and approve those, you may want to outsource that to an expert or have some indemnity agreement signed with your employer, because you have individual liability for making errors involving the I-9 as well. Involving LGBTQ plus employees, Trump issued another executive order that says the federal government only recognizes two genders, and they will no longer use these non-binary gender categories. And the Equal Employment Opportunity Commission rolled back much of Biden's era guidance on anti-discrimination and anti-harassment protections for LGBTQ plus employees. So even though there are federal law rollbacks, you still need to be well aware of your local state laws. And many local state laws apply to all companies that have one or more employees. But essentially, Trump is rolling back discrimination based on sexual orientation and transgender status. Next slide. So the key takeaways is that you should have your anti-discrimination policies reviewed. Essentially, under the Trump administration, it's not even called reverse discrimination. If you are a white male, you are just as empowered to seek discrimination relief as any other protected class. And you essentially probably need to update your policies and verify local law. Next slide. Next, federally, minimum wage hasn't changed in a long time, but every state, and I have a team of 18 employment lawyers that do handbook supplements in all 50 states. Be aware that Michigan minimum wage went up to $10.50, 56 cents on January 1st, but shockingly is going up almost another $2 a month and a half later. So be prepared to make that change. Next slide. The Department of Labor is issuing more guidance where if you have stipends where you give somebody $100 a day and they're using their own tools and equipment, they're evaluating whether or not you're really cheating that employee out of overtime. So if you're giving that employee money to use their own tools and you're somehow allowing that employee to save money on meals or tools that they're not actually incurring, maybe you're really making that employee happy by they're getting $100, but you're really making overtime cheaper because their hourly rate is a little bit lower. So what the Department of Labor is saying is that if they're not actually utilizing all of that expense reimbursement, you're going to need to increase their hourly rate or factor in that bonus commission expense payment as a higher overtime rate to not cheat that employee. So it's a good idea to have your daily stipends reviewed by counsel. Next slide. All right, now I'm going to get into the fun of today's presentation, which is storytelling. I believe the only way to educate and train is through telling real life stories. So I'm going to share some real life stories across the country so that we can all learn from. So in my first case, a delivery driver sued for unpaid wages, misclassification, lack of paid sick leave, etc. And the court said, you can't sue, we can enforce you to go to arbitration. So the good news is, if you want to stay out of court, I would have your employees sign arbitration agreements to protect your companies. So what I'm doing for a lot of clients is preparing a quick handbook acknowledgement or an agreement where employees waive class actions, agree to arbitration, agree to a reduced statute of limitations period to bring claims, and even allow the employer to get attorney fees if they prevail to minimize frivolous claims. Next slide. In this case, the court is essentially saying that agencies don't have authority to interpret law, and therefore, if an agency overreaches by making up how they want to enforce law, the courts have ability to strike that down because they aren't legislature. Next slide. In order to bring claims for wage and hour violations, such as being properly classified as exempt from overtime, some courts have said that it's the employer's burden to prove by clear and convincing evidence that the employees are exempt. But many courts, including in Michigan, are reversing and saying as long as an employer proves they're 51% right, preponderance of evidence, as opposed to clear and convincing, which would be a higher burden, the employer can win. Next slide. In this case, you have to evaluate if you're paying employees for all time worked. So for example, if you round time to the nearest quarter of an hour, you could be violating wage and hour laws. Specifically, in Michigan, under the Michigan Wage and Fringe Benefits Act, you have to calculate time in 1/10 of an hour increments, which means that you have to calculate time in 6-minute increments. So not 15 like you can under federal law. So the question here is whether boot up and shut down time on a computer was time that must be compensated. And the court said there still could be a de minimis time that is not compensated. There's no bright line rule. You'll have to look at it by case basis. Next slide. This is just another example where you can argue the time is de minimis. Someone said the time spent showering after doing work should be paid, and the employer must prove that such time is de minimis and plead it as an affirmative defense to a lawsuit. Next slide. Essentially, if you don't have a class action waiver that your employee signed, you are desperately exposed to class actions. Because if somebody claims they aren't being paid properly, the odds of that applying to other people too are very high. So what plaintiff attorneys are doing is starting to argue that we're gonna just sue you in every location in all 50 states that you have and pick a jurisdiction that is inconvenient to the employer and force every lawsuit across the country into one case. And so what smart defense attorneys are doing is trying to make it more complicated, saying there's no personal jurisdiction for the employer to have to litigate in other states. They need to be sued in their headquarters. And there are ways to argue that employees have to take the cases individually because maybe there's a different fact pattern in each state. But if you are unable to stop the class action, you are exposed to millions of dollars of liability. So maybe a good time to update your policies. Next slide. This is getting a little bit geeked out, but essentially it's harder for employees to prove their class action claims because employers can point their individual facts and circumstances at various locations. Next slide. Likewise, it's easier for plaintiff attorneys to prove age discrimination. They can also bring class actions on age discrimination if there is a pattern or practice of replacing older workers with younger workers. Next slide. And there's a question about how do these laws affect 501c3 businesses or nonprofits. All of these laws apply to you if you're at 15 or more employees. Next slide. So pregnancy is now the most protected class in the country. And I'm going to cover a pregnancy case. So in this case, somebody claimed that they were discriminated against for being pregnant, and the employer fired them and still won. And how the employer won is they said the layoff was due to that employee having low productivity and was part of a system-wide initiative. So if you're going to terminate somebody, it's great to have a bright line, clear basis for that layoff. So I would argue that there really isn't such a thing as at-will separation anymore. Instead, you need to identify your bright line, legitimate reason so that you can use that to rebut potential claim for discrimination, because all of us are part of multiple protected classes. We're either male, female, have a certain race. And in Michigan, we protect height, too tall, too short, weight, too heavy, too thin, marital status, whether you're single or married, misdemeanor arrest record, and other protected classes. So make sure you are aware of the protected classes in all of the states that you have employees. Next slide. But just because you have employees that are part of protected classes such as pregnancy doesn't mean that you cannot terminate them for legitimate reasons. So in this case, another pregnancy case, the employee alleged sex discrimination after being denied an accommodation to go to doctor's appointments and said that she experienced a hostile work environment for being pregnant. And the court said that the plaintiff did allege discrimination. So therefore, you need to evaluate your legitimate non-discriminatory reason. And the court found there were sufficient grounds to allege pregnancy discrimination. And therefore, the case got to proceed in the litigation process. So what that means is if an employee has some basis to allege discrimination and we don't have clear evidence as to legitimate reasons to terminate, that means the case will not get dismissed right away in court, which means it'll cost the company $100,000 likely in legal bills to take depositions, to do discovery, to get down to what the actual facts actually are. And that is bad for companies because usually that means they're likely going to be incentivized to pay out that $100,000 or more to that employee, because even if they win at the end of the day, they still spend $100,000 on legal bills. So that will be a monetary impact on the company. Next slide. In this case, a female diver alleged that she was discriminated against because she was female. She said that, yes, she wasn't the best at some knot tying contest, but she was also prohibited from driving a company vehicle and subject to verbal abuse. And she won the case because it's a two-part test, even though it seems like you should be able to fire somebody that doesn't tie a knot well or potentially has a driving issue. What happened in this case was there was a male diver who got in a car accident and he wasn't fired. So there was evidence that men and women were treated differently. So when I say it's a two-part test, you have to evaluate the totality of the environment and see if there are any other low performers that are not being terminated of different protected classes. And if that's the case, then that strengthens that employee's claim. Next slide. In this case, the superintendent alleged discrimination based on race and national origin after being placed on leave and investigated. And the court granted the employer's motion to dismiss because the plaintiff took leave due to stress and was replaced temporarily. And so upon return, a plaintiff was barred from work and investigated, but the court found no adverse action because if you suspend somebody with pay during an investigation, that is not an adverse action. And therefore, there is no harm in terms of conditions of employment. So essentially, there was no claim to be made by that employee. So a good tip is to potentially pay an employee pending an investigation so they don't sue you and allege discrimination based on the facts. Next slide. In this case involving Delta Airlines, kind of a shocking case where the lead aviation technician didn't fix a maintenance error. And she also failed to disclose that she was aware of an error. And so because of this, it was eventually detected, and that led to a rerouting of that aircraft and more work that had to be involved to fix it. She was terminated for what appeared to be a bright line error and also not seeking help or disclosing the issues and having other performance issues. However, she claimed that there were male employees that did similar things and were not fired. In this case, the court found that sex was not a motivating factor because, she essentially almost killed many people. So if you have a bright line reason to fire, usually that can save the day. Next slide. More cases involving sex. In this case, there was like a student intern that said she was sexually harassed by her advisor. The court tried to dismiss the case or the employer, saying that you're not an employee, you're just an intern student. And the key points are that, a student that is doing research work could be deemed an employment relationship. So be careful, even if you have an independent contractor or an intern or a student, they potentially still could bring claims. Next slide. In this case involving a race-based claim, an Italian American claimed he was discriminated against for being Italian. And it turns out the commissioner actually did make derogatory remarks about Italian Americans and was criticized publicly. However, the employer still won. How did the employer win? The employer won because the decision to terminate was decided by the board and not the commissioner. So this is a really great test for all of you to learn from. Instead of letting your managers or supervisors have the ability to fire employees or just go to HR and say, fire that person. If instead you created a board or a panel, let's say it's your outside attorney, your CEO, HR, and maybe somebody else, that panel is much less likely to discriminate or retaliate against that employee. They may not even be aware of any protected classes or claims. So if you have a board that evaluates the facts and performance of that employee and decides whether or not any employee should be fired based on those performance metrics, that can be a slam dunk defense to these claims. So essentially, it's a great idea to bring in outside consultants or legal experts to help you make termination decisions, especially if there was some bad acts in your company. Next slide. In this case, there was an African-American sergeant that alleged a hostile work environment. Essentially, this was in Detroit, and the sergeant was at a gas station off duty. And apparently, police officers on duty were investigating a suspicious package. And the plaintiff was told to stand down and leave the gas station. And the plaintiff ignored the commands. And the plaintiff said, I didn't even know who the people were that were yelling at me and if they were legitimate police or not. And what the plaintiff did is used his police powers to go to the gas station and get the surveillance video to try to prove he was exposed to inappropriate acts by fellow police officers. And the police officer, police department said he was fired not because of his acclaim for hostile work environment. He was fired because he interfered with their investigation by doing his own investigation and using his police power to get a police video. So the court essentially said there's enough evidence to conclude retaliation because as soon as he alleged hostile work environment, he was treated inappropriately. So that was not a good enough reason the employer came up with to fire that employee. Next slide. In this case, there was an African-American woman alleging race discrimination, and she has 30 years of positive evaluations and promotions. And the plaintiff claimed that there was denial of insurance claims to mainly minorities. She felt that there was retaliation after raising that issue. And the district court granted summary judgment for the employer, but on appeal, the court found evidence to determine that she was fired due to the suspicious timing and lack of earlier corrective action. So moral of the story is if someone has a 30-year or a long track record of positive performance evaluations, you probably shouldn't fire them without a smoking gun of issues. Next slide. In this case, there was an African-American male that alleged racial discrimination because he tested positive for a drug test. And he signed a second chance agreement and a last chance agreement and was eventually terminated after testing positive for marijuana. And he argued that white employees also had marijuana in their system and were not fired. The court granted summary judgment for defendant, but on appeal, the court reversed in favor of the employee and said there is a material fact issue as to whether or not white employees would have had to sign this last chance agreement. And because white employees didn't get the same treatment, maybe there was discrimination. Next slide. In this case, a Chinese woman alleged discrimination after not being hired for a teaching position that was given to a white native English speaking woman. The court granted dismissal in favor of the employer, and the Sixth Circuit Court of Appeals agreed, finding that there were legitimate reasons as to why she wasn't hired, including concerns about her interview answers and professional boundaries. And just making a random allegation without any evidence supporting that is not enough to prove discrimination. Next slide. In this case, a plaintiff alleged national origin discrimination for being tribal. And the court said being Native American is not even a recognized tribal protected class. So therefore, your claim is dismissed. Next case. In this case, a Muslim alleged discrimination and essentially claimed he was ignored in meetings, was treated unprofessional, virtually, and harassed during a work trip. And he was terminated 5 days after speaking up about the work environment. The court denied the employer's ability to dismiss the case, finding that the timing was very suspicious. And so therefore, because if something happens within 5 days or even 30 days of raising an issue, it does appear to be discrimination unless you have a smoking gun reason of a performance issue. Next slide. In this case, an employee worked for a Christian-based company, and this employee was also Christian. But what happened is when there was a COVID-19 pandemic, the Christian faith believed that you could still die from COVID. So he wanted to wear a mask and socially distance. But this religious culture at the company didn't really believe in masks and distancing and believed you should just pray and hope for the best and good things will happen. And so the court said that the company essentially discriminated against that employee because the employee was wearing a mask for his own religious beliefs, and defendant's policy of prayer as a way to prevent COVID violates that employee's religious belief, and therefore that employer can be held liable. Next slide. In this case, a plaintiff alleged her religious beliefs were violated because of a COVID-19 testing policy. And the court disagreed, saying that her objections to getting testing was more based on her medical opinions or not wanting invasiveness. There was no religious ban on such testing, and there could have been alternative tests that were offered to this employee that she rejected that would have complied with any alleged religious issue. So objections based on personal moral codes or personal medical opinions are not a protected class. Next slide. In this case, an employee alleged that she was terminated because she was over 40. Essentially, at age 58, she alleged that was factored in to her reason to be terminated. And the court denied the employer's ability to dismiss the case, saying that this employee had 3 decades of experience and was actually replaced by a younger insubordinate that had less experience. So they didn't provide a good, legitimate reason why to terminate such worker. So essentially, if you're going to terminate somebody by claiming that they're not a great worker or don't have good experience, you better have evidence to back that up. Next slide. In this case involving another law firm in town, the administrative assistant said that she was discriminated against. Essentially, what the employer did is made fun of the employee and said, "When are you going to retire?" and posted adult diapers at the employee's workstation and asked that employee, inappropriate questions based on age. However, the employer still won. How did they win? Well, the reason was similar to the earlier case I went over. That attorney did not have the ability to make hiring and firing decisions. And plaintiff failed to show that her termination was not actually based on performance issues because there was a clear track record of performance issues. So even if there are inappropriate acts at a company, you can still fire an employee for performance issues, especially if the bad actor is not the decision maker in hiring and firing. Next slide. In this case, there was a site manager that said there was a toxic work environment. And once he reported harassment, he started being treated inappropriately and was no longer able to get a promotion. And so essentially by taking away an employee's security camera access and not giving them a promotion they were in line for, could be evidence of discrimination. And so plaintiff's termination, closely followed by the harassment report, was enough suspicion to allow the employee to continue on with the case. Just blatantly saying the defendant was restructuring and there was some performance concern without much evidence was insufficient to win this case. Next slide. In this case, just be aware, if you want to bring a federal claim of discrimination, you have to go to the Equal Employment Opportunity Commission first. And the employee tried to go directly to state court. And after they won $10,000, they tried to then go to federal court and go through the EEOC, and you can't double dip. Once you bring a claim in one forum, you're barred from seeking damages in the other forum. Because the claims involved all the same parties and the same facts. Next slide. Likewise, in this case, a plaintiff filed claims under federal law and also brought in a bunch of state law claims, and the court dismissed it, saying you didn't go through the agency first. So then the employee went to the state law court, Wayne County Circuit Court, and the court granted a motion for summary disposition to defendants, finding that the claim was already barred based on the federal court's finding of dismissal. Next slides. So now wrapping up, we finished discrimination, and we're going to wrap up with disabilities and FMLA and missed time from work. So in this case, the employee was denied leave to care for her sister. So this is a good ESTA refresher too. So under the Family Medical Leave Act, you can care for somebody that you are the parent of or that is your child. And in this case, the employee wanted to miss up to 12 weeks of work to care for her sister, which is not specified as a reason to take FMLA leave. However, the employee still won because the employee said, my sister doesn't have the ability to care for herself, so I am essentially her primary caregiver like a parent, and therefore, because our relationship is in loco parentis relationship, you are guilty for violating my FMLA rights. So it's a good idea to be aware that FMLA can apply to taking care of a sibling if you are in loco parentis relationship. And likewise, ESTA says if you have a close affinity with that person, you can also miss work for one of the permitted reasons for being sick or a sexual assault hearing, etc. Next slide. And this is just more details explaining that if there is a child that is over 18 but incapable of caring for themselves due to a disability, you can still be determined to be the parent. Next slide. Under the Family Medical Leave Act, there are a great defense companies do is say, I didn't fire you for taking FMLA. I fired you because you didn't follow our handbook, usual notice and procedural requirements for seeking leave. And in this case, the employee won because they essentially said the employer's strict rules of 30-minute reporting before a tardiness or absence is so strict that you aren't actually evaluating the facts and circumstances to see if maybe the medical condition prohibited that employee from providing notice in time. So therefore, because you gave that employee a point and didn't excuse it, you may be liable. So therefore, you want to make sure the employee doesn't have a good excuse as to why they didn't follow your policy, because sometimes their disability or need for leave should be excused. Next slide. In this slide, there was an employee that was out on leave. So a lot of employees, if they think they're about to be fired, sometimes seek FMLA leave because they're stressed out, or seek leave because they think that's going to protect their job and prohibit the employer from firing them for a while because they just asked for leave. So in this case, a professor was disciplined mid-semester. He then sought FMLA leave, and the professor argued that he was being discriminated against, and the FMLA does not erase conduct that has occurred before the employee seeks FMLA leave. So therefore, when the employee was done with FMLA leave, the university said, we still don't need you. So therefore, you're still on unpaid leave, and the employer won because there were issues prior to that employee leaving. Next slide. In this case, FMLA requires you to go back to your exact position or an equivocal position. And in this case, the employee took FMLA leave due to premature birth complication while that employee was already on a COVID-related layoff. After the employee's 12 weeks expired, the employee said, I'm ready to come back. And the employer said, well, we have no duty to bring you back to the same or equivalent position because we put you on a COVID-related layoff unrelated to your leave request. And therefore, we're going to keep you on that COVID-related layoff that we're entitled to do. Next slide. In this case, the plaintiff said that they had post-traumatic stress disorder, and essentially altercation that triggered that employee's post-traumatic depressive disorder. And the employee said, you need to accommodate me because I may encounter this employee that triggers me again, and I don't want to be exposed to that employee. And the jury ruled in favor of the employee, saying that even though the plaintiff may have not been unable to earn a livelihood or have any major life activity of working be banned, it is true that we expose that employee to a violent situation. And because we couldn't guarantee we would avoid triggering that employee, they were disabled, and therefore we should consider accommodating them. So the moral of the story is that it's nearly impossible to claim someone's not disabled. The courts would rather you focus on whether or not you found a way to reasonably accommodate an individual that claims to have a disability that substantially limits a major life activity. Next slide. Oh, and then one question, someone said to revisit the loco parentis as it pertains to FMLA. Someone was under the impression that it was for when an employee is caring for someone who stood as their parent, not the employee is standing in as the parent. Yeah, I don't really understand your distinction. I do agree that it is caring for someone who stood in as their parent. I don't necessarily mean that they are standing in as their parent. I'm happy, maybe read that case more to get the full definition, but I don't fully understand your distinction. Okay, in this case, the employee was a floater, and the employer said, I have a bright line reason to not hire you. We have a very prompt start attendance, start time and end time, and because your disability doesn't allow you to always show up on time, we can't have you. And the court disagreed, saying because you weren't hired for the normal shift time, you were hired to be kind of the floater, to be overflow help back and forth for people. You haven't really proved to us that being promptly on time is an essential function of the floater position. So if you're going to terminate somebody that can't do the job, make sure it's an essential function of that job. You aren't just making up some essential function. Next slide. In this case, the employee was threatening to kill people, and the employer cared about that employee and said, let's get you a evaluation to make sure you're okay. And the employee said that violates the employee's constitutional rights. They don't want to be evaluated. And the court found that even though the employee may have a right to refuse unwanted medical treatment, getting an evaluation doesn't require any course of medical treatment and would not violate that plaintiff's person. So the employer won. Next slide. In this case, the employee had Tourette syndrome that essentially involved them swearing at customers and speaking inappropriately toward customers and getting complaints. And the essential function in the job description was that this position, interacting with customers, requires you to have excellent customer service. And so the plaintiff employee said, okay, well then reassign me to a position that doesn't interact with customers. And the employer agreed to transfer them to a warehouse position. But the employee sued, saying this is a lower grade position. I'm getting paid less money. And the court said it's fine to transfer you to a lower level position that we're advertising for, even if it's less money. We don't have any requirement to create a new job for you to accommodate your disability. Next slide. In this case, whenever someone has a disability, you're supposed to engage in what's called the interactive process and see if there is a solution to get that employee to perform better or do all of the essential functions of the job. And so the company did not want to create a new position to accommodate the disability, and the company rejected the employee's application for other positions, saying that they hired more qualified candidates for that position. So under the Michigan Persons with Disabilities Civil Rights Act, the employer has no duty to accommodate a disability by creating a new position or hiring you over more qualified people for other positions, and does not require you to hire someone simply because they asked to be reassigned. So pro-employer. Next case. In this case, what is the employee's responsibility to be part of the solution? So a lot of great HR leaders say, don't come to me with problems. I encourage you to come to me with solutions. So in this case, the teacher requested to work remotely because they have a compromised immune system. And the school said, hey, we're willing to work with you, work with us. If you can't be exposed to kids because of your compromised immune system, why don't you come to a private office here or come to our gym where you can, work remotely within our building as an accommodation? And the teacher said, no, I'd rather just work at home my entire life. And so the court said, when there is more than one reasonable accommodation offered, the choice of the accommodation belongs to the employer. And the employer who rejects a reasonable accommodation will no longer be considered a qualified individual. So essentially, the employer gets to decide the accommodation, not the employee. And the employee should have been more flexible in exploring that employer's solutions. Next slide. So we've now had about an hour presentation. and I covered what I consider to be the hot legal issues of the past year. But all of you may have your own hypotheticals that a friend of yours asked you to ask me about. So now is the time for free legal advice if there are any questions. And if there are no questions, please put in the chat one comment of some positive takeaway thing you learned so we can all try to apply today's training as well and have a good takeaway. Thank you.
Thank you so much, Jim. Did anybody have any questions? Oh, Lisa Rogers, go ahead, please.
Yes, thank you for the presentation. This was very informative. My question is in regards to the extended sick leave. If we have separate time off banks and already offer, say, 48 hours of sick time, and we have another bank that offers an additional amount to get up to 72, and in that bank you can use it for any reason, would we comply, or would we have to call the bank actual sick time?
There is a way to get your generosity of a vacation bank plus a ESTA bank to comply. You just have to make sure the vacation bank is as easy to elect as the ESTA bank. For example, most vacation banks say you can only use this time if more than 30 days advance notice are requested. So you'd want to have some provisions that say that the vacation bank can be used for all the reasons permitted in our ESTA policy as well for ESTA related reasons. So yes, there is a way to make it likely comply, but you would still have to draft a little more to that policy because you still have to address how you're going to deal with accruing hours if they work more than 72 times 30, so 2160 in a year. They may accrue more hours to carry over to the following year. So yes, you're good. Just will take some creative wording in your policy.
Okay, thank you.
Yep.
Are there any other questions for our phenomenal speaker, Attorney Reed? Okay, well, we really appreciate you attending today. We know everybody's very busy. Oh, go ahead. Who's speaking?
I'm trying to unmute myself. This is Katrina Royster. Quick question, James. Excellent presentation. Regarding the Michigan law, the call, like the call-in policy now, meaning like a person doesn't, you can no call, no show up to 3 days without being disciplined. I know you didn't cover that, but do you have any?
Yeah, so I think that's a little bit of an extreme interpretation. So the fear that employers have is that under ESTA, you essentially can't ask any questions or documentation or a doctor's note as to why they need to miss the first 3 consecutive days. So I think some ultra-conservative companies or attorneys are saying that means you can't fire somebody during that period. And I am more aggressive. I would say that the only time you would excuse a no call, no show for 3 days is if they were in a coma. Maybe later on you would pull that back, but I would still follow your no call, no show procedures. There's nothing in the law that says you can't ask the employee to give you notice if they need to miss work. It says they have to give you 7 days notice when foreseeable.
Thank you, James.
Okay, we have a question from Mr. Patrick Tesler. Please go with your question, sir.
Oh, he actually just answered the question right after I raised my hand. So I just wanted to clarify, we can require notice when using ESTA. So currently our procedure requires at least an hour prior to your shift starting in the collective bargaining agreements. Can we require that with the use of ESTA?
Well, if you have a collective bargaining agreement, you can just follow your agreement and ignore ESTA for now. But
well, we have one agreement that doesn't have sick time, so we're going to be providing sick time under ESTA, but they do have a requirement to call in prior to, whether it's a normal call in or whatever, they have to call in an hour before their shift to provide notice. So that would still apply, correct?
That would still apply, but I would have
Okay.
a mechanism to hear the employee's excuse. So if for some reason they say they're in ER, I would probably not write them up for that 1 hour violation.
Yeah, I want to be reasonable on that end, but if they don't call,
Yep.
we could still hold them accountable to the CBA,
I-
not under ESTA.
I would say yes. However, the law is not clear on that. There is a proposed
course.
amendment that says
Yep.
companies can follow their normal call-in procedures. So because someone proposed that in an amendment means it's not crystal clear, but I would argue that yes, you can still enforce your procedures. And the next question is, can you ask them to even sign a form that they want to take ESTA leave? I would argue yes. I don't see where that's prohibited, but there also vice versa. It doesn't say anywhere else where you can require that like FMLA does.
Yeah.
All set, Patrick?
Good. Thanks.
Thank you so much.
I do have
Yeah.
a question, Vanessa, kind of piggyback off that.
Okay,
So-
Heather, go right ahead.
So under our current system here, if an employee calls in, we have a bank of time. If they call in absent, we require them to use that time to cover that absence. Are we still allowed to do that?
I would argue yes, although there is a proposed amendment to ESTA that says you can run all of your policies concurrent. So that means at least someone thought it wasn't crystal clear, but I would argue that yes, as long as you are at least allowing people to use time for ESTA, you can be more generous and allow them to use paid time for vacation or otherwise, and still force that to count toward ESTA hours.
All set, Heather?
Yes, thank you.
Okay, thank you very much for the question. Jim, I believe there's a question in the chat for you. It says, can we request they sign a form that they are using ESTA time?
I would argue yes, because you don't have to allow somebody to call in later, miss work if it's not ESTA related. There's permitted reasons you can use ESTA, so you could get them to at least verify it was one of those permitted reasons. If they call in and say, I had a flat tire, that is not required to be ESTA related, so you could hold them accountable as you see fit.
Thank you. Thank you very much. Katrina, would you like to close out the meeting?
Sure. I hope everyone enjoyed the presentation today given by James Reed. We can give him a round of applause. You can do your the confetti or whatever you choose to do to let him know you appreciate his time and his information that he gave to us today. And James, we look forward to maybe having you again in the future.
It looks like we have another question. Heather, did you have another question?
I think they're trying to do hands up oh, I see what you're saying.
No, I don't have another question.
Erica Fox, did you have a question? Okay, I saw some hands go up. Sorry, Katrina.
They were just clapping. I think they were trying to hit the
Oh.
they were trying to hit the wrong emoji.
I didn't mean to interrupt you. Go ahead, Katrina. I'm
Oh,
sorry.
no worries, no worries. I was done. I was just saying that we look forward to maybe having you again in the future, James.
I would love to be honored to come back.
More information to come regarding our next meeting. Everyone will receive an email via from Vanessa as it relates to our next meeting. I think it's going to be in April, Vanessa. Is that correct?
That's correct. That's correct. Yes, it is.
So more information to come regarding that. If you have any questions, please feel free to respond to Vanessa's email that went out to everyone. Please feel free to share with other HR colleagues or anyone that your friends that you know who may show a vested interest in this joining our association. Please feel free to share as well. Thank you.
Thanks all.
Thank you. Jim, I'm going to give you a quick call, okay?
Okay, great.
All right, thank you. All right,
Have a good day,
bye-bye.
everyone.
Bye.
Bye, everybody. Have a great day.
Bye. Have a good one.
You
You have a
too.
great day also.
You too.
Thanks
Thank
so much.
you.
Thank you.